They did not want you to hear this. They did not want you to know this recording exists, and they certainly did not expect it to become the most downloaded political audio clip in the world. 37 seconds. That is all it took to turn a sealed courtroom decision into a full-scale constitutional crisis. 37 seconds of audio leaked from a secure briefing room inside the vice president's residence, capturing J.D. Vance, a man known for discipline, message control, and restraint, completely losing control. Not a metaphor, not political theater, but what multiple officials inside the administration are now calling a constitutional war. Because what happened inside Judge Caldwell's courtroom was not routine. It was not procedural. It was not normal. And according to senior legal experts across party lines, it may represent the most aggressive judicial challenge to executive authority in modern American history. Tonight, U.S. News Nexus reveals what happened, why Witness 14 matters, what Judge Caldwell did, what J.D. Vance said, and why the United States may be approaching a moment that permanently changes how power works in this country. The moment everything broke. Tuesday morning, federal courthouse, secure floor, restricted access. Witness 14 arrived under U.S. Marshal protection. This witness is not a criminal defendant, not an undocumented migrant, not a random informant. Witness 14 is a cooperating federal witness in one of the most sensitive immigration-related corruption cases in decades. According to multiple officials with direct knowledge of the case, Witness 14 was prepared to testify about coordination between certain judicial officials and outside advocacy organizations, allegedly working to obstruct federal immigration enforcement. That testimony was scheduled, prepared, locked in. Then Judge Caldwell entered the courtroom. He did not sit. He did not greet counsel. He stood behind the bench, shuffled two papers, and spoke. Due to emerging national security concerns that I am not at liberty to specify, this witness will be remanded to federal custody, pending further review. No hearing, no briefing, no sealed explanation, no opportunity for objection. When the government attorney stood to protest, Judge Caldwell cut her off. This court's authority supersedes your AY's preferences. Preferences. That word matters, because federal witness protection is not a preference. It is statutory law. 3 minutes later, Witness 14 was removed through a side door, jailed, silenced, and the entire proceeding was sealed. But the court reporter was still recording. The audio that reached the White House, within hours, that courtroom audio reached DOJ leadership, then the White House, then Vice President J. Vance's secure line. Vance reportedly listened to the courtroom recording 3 times. On the third playback, he stopped it at the word preferences. According to 2 officials in the room, Vance looked up and said, "That's it. That's the line." Moments later, someone activated a recorder. What followed is the 37-second clip now circulating globally. This judge just imprisoned a federal witness to stop testimony about judicial coordination with outside groups, and he thinks we're going to file an appeal and wait 6 months. Sir, the proper channel. That's exactly what he's counting on. Pause. If Judge Caldwell wants a war with the executive branch, he just got one. I want every tool we have on his desk by Friday. Every legal option, every enforcement mechanism, everything. Separation of powers goes both ways. He just separated a protected witness from his constitutional rights. Now he learns what happens when the executive branch stops asking permission. The list worked. End of clip. 37 seconds. That is what detonated Washington. Why? This is unlike anything before. Federal judges have enormous authority. They control their courtrooms. They rule on classified matters. They issue detention orders. All true. But legal scholars say something critical. A judge cannot jail a protected federal witness to prevent testimony without due process. A judge cannot override witness protection statutes without making a formal record. A judge cannot seal a proceeding to block appellate review while claiming national security without invoking proper legal mechanisms. Judge Caldwell did all 3. That combination is almost unheard of. One former federal appellate judge described it as not just aggressive, not just questionable, but structurally destabilizing. Another said, "This is the closest thing I've seen to a judge directly inserting himself into executive operations." the 6-week escalation. This did not start Tuesday. For 6 weeks, Judge Caldwell had been steadily expanding his interventions, staying deportation orders, demanding privileged executive documents, holding DOJ attorneys in contempt, issuing rulings framed in moral language rather than statutory interpretation. Internal DOJ memos show growing concern. One memo reads, "This judge is no longer interpreting law. He is substituting policy judgment." 3 days before Witness 14 was jailed, Judge Caldwell received a sealed ex parte filing from an unidentified party. No one outside his chambers has seen it. That filing changed everything. Suddenly, Witness 14 became a national security concern. Suddenly, testimony was delayed, then canceled. Then the witness was jailed. The administration's position, the White House position, is blunt. Judge Caldwell used national security as a pretext to obstruct testimony that would expose judicial misconduct. Vice President Vance later confirmed the leaked audio publicly. "Yes, that's my voice. Yes, I said it. And yes, I meant every word," he added. A federal judge used his courtroom to obstruct justice. That is a crisis. Behind the scenes, federal agencies have reportedly begun reviewing compliance frameworks with court orders. Translated, which orders must be followed, which can be challenged, which may be ignored. That language alone is unprecedented. The judiciary's response: Judge Caldwell issued a statement. The judiciary will not be intimidated. This court will continue to fulfill its constitutional obligations regardless of political pressure. He also said the witness remains in custody for his own protection. Protection from what? Protection from whom? The judge did not specify. The administration responded, if Judge Caldwell believes the vice president poses a threat, he should say so under oath. Where is Witness 14? No one will say. Not DOJ, not U.S. Marshals, not the court. The marshals previously assigned to him have been reassigned. His attorneys have filed emergency motions. Judge Caldwell has refused to hear them. A man who walked into court under federal protection is now effectively disappeared into sealed custody. That alone would be a national scandal. The list worked mystery. That background voice, the list worked. Multiple intelligence analysts say it suggests pre-planning that Witness 14's detention may have been coordinated, not spontaneous, not judicial impulse, but part of a larger strategy. Sources tell U.S. News Nexus the administration has identified 2 advocacy organizations that had unusual communication patterns with Judge Caldwell's chambers prior to the detention. Judicial ethics investigators are reportedly being assembled. Announcements could come within days. Why this is a legitimacy crisis? This is not left versus right. This is not immigration. This is not even about one judge. This is about who has the final say when branches of government collide. Courts do not have armies. Executives do not issue rulings. The system only works if both sides voluntarily respect limits. Legal scholars call this a legitimacy contest. When both sides claim the other is fundamentally illegitimate, normal rules collapse. There is no referee, only power. What happens next? According to senior officials, executive enforcement options not used since the 1950s are being reviewed. Federal compliance with certain court orders may be selectively challenged. Judicial ethics probes into sitting judges are imminent. At the same time, federal judges are holding emergency meetings. Some are requesting security details. Circuit courts are preparing coordinated responses. This is not cooling down. It is accelerating. The bigger question: what if the administration is right? What if judicial networks really are coordinating with outside groups? What if courts have been weaponized? And if that is true, what is the lawful response? Appeals that take years, polite objections, or confrontation? What if the judge is right? What if there really is classified information justifying detention? What if the executive branch is trying to intimidate courts? Both realities cannot coexist. One side is lying, possibly both. But the system cannot survive unresolved. Final thought. This stopped being about one witness the moment that audio leaked. This stopped being about one judge the moment the vice president confirmed it. This is now about who actually controls the machinery of American government. The people who win elections, or the people who never run? U.S. News Nexus will be here as this unfolds. Rachel Maddow will be here, because when this breaks, and it will break, you deserve to understand what happened, why it happened, and what it means. Subscribe, turn on notifications. History is moving and you are watching it in real time.